age-old and are there for a purpose. The court went ahead to say, the petitioner has chosen to come to court. He has not chosen to go and present his case in a marketplace. Therefore, leave the court to do their work. That's in quotations. So, my lords, you must forgive me for telling you how disheartened I am at how this whole matter is being played out in the media. More or less seeming to amount to some intimidation of sorts. This cannot and must not continue. I have the highest respect for Honorable Segona, whom I'm not shy to say is a friend of mine. He was in this court, and I think he's well aware of the rules, and if his client isn't, he should make him so aware. The only description I could come out with myself as I was reading and watching the press and the interviews was that was this an attempt at a trial almost by blackmail. As I've already said, a recusal application is allowed in the law, but the venue is very well known. Therefore, and my lords, when you go to Article 128 of our Constitution, that talks about the independence of the judiciary. 128.2, if you might allow me to read it, it says that the article is 128 talking about the independence of the judiciary. 128.1 says, in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority. Number 2, 128.2 says, no person or authority shall interfere with the courts or the judicial officers in the exercise of their judicial functions. I dare submit that what I saw the other day was an attempt at interference. Not to belabor the point, my lords, I humbly request that this court takes appropriate remedial actions to bring us all back into line. I thank you, my lords.
Counsel for petition, you have something to say?
Yes, my lord, to the extent that my name has been mentioned. First,
He has also named your client.
true, my lord. As you will appreciate, my lord, instructions are specific. And let me be on record stating that with respect to recusal, which I have had the learned Attorney General talk about, I have no instructions of any kind, whether specific, general, or otherwise. I want to reaffirm my knowledge and support of for Article 128 as has been read out by the Attorney General. It is the cornerstone of our practice as lawyers to accord the necessary respect to courts. Otherwise, there will be chaos. 3, my lords, and I wish to complain now that my learned friend, the Attorney General, who is the head of the bar, has not, until this morning when I went out of my way to greet him, raised this issue, which would give me ample opportunity to interrogate the same and probably seek instructions, if any. I agree that a matter in court should be in the exclusive hands and four corners of court and nowhere else. And that has been my practice for the last 18 years. The Attorney General has equally not availed me with an opportunity to look at the material that he was able to look at. But my undertaking from the bar, my lords, is as follows. 1, immediately after these proceedings, to have an engagement with the applicant and know the circumstances and context with the applicant, my lord. That's my client. To know the circumstances and context in which he said those words, if he did. My second undertaking is to undertake a duty.
Councillor Bega,
Yes, my lord.
you are the lead counsel for the petitioner. Have you heard, is this the first time you are hearing about what the learned Attorney General is speaking about?
No, my first
You,
was
you didn't know about it until when he raised it?
until I saw an affidavit yesterday sworn by the Honorable Stephen Tashobia
Ah,
that he was talking about words similar
so
to
you,
those.
in other words, you were the only person in Jerusalem who didn't know about these things.
No, my lord, I don't know much about Jerusalem. I would be pleased to. But the point I'm making, I received this affidavit of Honorable Stephen Tashobia yesterday evening as I was leaving office.
Okay.
I went with it and read through the affidavit, and unfortunately, it did not trigger my action of calling the applicant.
Fine, fine.
To talk to
Proceed,
him.
proceed, please.
That said, my lord,
I was just seeking clarification. But proceed,
I'm
yeah.
most obliged, my
Yeah.
lord. That said, my lord, like I did say, I would definitely take up this matter, with or without instruction of this honorable court, now that it has been raised by somebody senior, and I take it as a serious matter. The prayer, my lord, raised by the Attorney General, I am not averse to further guidance and direction of this honorable court. With or without them, I have and undertake a duty of a professional advocate. I thank your lordship.
Okay. Any other person wishes to say a word? Learned Attorney General, Learned Councillor Bega, thank you so much for this presentation coming by way of preliminary statement. Let me state this on my behalf and that of the court. My sisters and brothers sitting over this case. As you said, the Learned Attorney General, I was quite clear, or at least I thought I was. The last time we sat here, I spoke in no uncertain terms on how we will conduct the modus operandi, how we will conduct ourselves. The matter you've brought before us today, you fear it is a scheme to bias this court or to intimidate or blackmail this court by the vilification of a number of justices of this court, including the Chief Justice. I just want to say this. The lordships, as is provided for in the Constitution, took an oath to protect the Constitution. In the oath, we all took oath, and I'll read it out verbatim. Each one of us said, I will well and truly exercise the judicial functions entrusted to me, and will do right to all manner of people in accordance with the Constitution of the Republic of Uganda as by law established, and in accordance with the laws and usage of the Republic of Uganda, without fear, favor, affection, or ill will. Guided by these principles, contained in the oath we took when we become judges, one, a matter which circulates outside of court, we do not attach any importance to it. As you rightly said, if anybody has a grievance, if anybody has any issue to raise with any of the judges here, this is the forum. They come before us, present their case, and we attend to it without fear, without favor, without affection or ill will. Let me also say this. Fortunately, I know the Chief Justice of Uganda very well. I think I've known him since childhood. If anyone thinks he can intimidate, he can blackmail, he can induce with favors that Chief Justice of Uganda, then he's heading for a crash against a huge rock. Because one of the things the Lord God denied him is fear. Once he has conviction that what he's doing is right, and if it is a judicial function, he's doing it in accordance with his understanding of the law as he has applied to the evidence, you may have to make a discovery that the person you think you know, you do not. So speaking for the Chief Justice, whom I know very well, Counsel, rest assured that whatever is circulating outside there will have no bearing in how this court will determine the matter before us. As a matter of fact, this application came after the alleged utterances. Then that is evidence that what was being said there was idle talk. It was meant for whatever reason, but I consider it idle talk. Because if somebody truly has no confidence in me, he will not come before me seeking remedies. The first thing he would have done was to come to me and say, I want to proceed with my case, but I want you out. I want Judge A out, Judge B also out. This has not happened, meaning that was just idle talk, whatever the purpose was, assuming it was done. So I give you the assurance, we will proceed with this application, we'll proceed with the petition, and nobody should have the fear that we will favor any person or we bear ill will against any person. We'll act according to the dictates of our oath. And for me, the only thing I fear is my conscience. If I go home and I don't sleep after hearing a case, then something is wrong. I wake up and rethink. But when I make a decision and I go and sleep until morning, then I know I am at peace with my conscience. That's what matters. Not what you think of me, but what my belief is. We are not opposed to fair criticism. I said this before. and the positions we hold, we expect criticism. But criticize my conduct, criticize my decision, tear it to pieces, but why attack my person? When you know I do not have the opportunity to stand up there and respond to you. First of all, it is cowardly. Because you know I do not have the opportunity to stand up there and respond to you. Indeed, if the learned Attorney General had not raised it, we would have kept quiet, but I thank you that you did. It's given me the opportunity to let everybody, all and sundry, know that you can choose to vilify us 1,000 times. But when you come before us, that one will ignore. If you have a good case, I will decide in your favor. That notwithstanding, because that is the oath I took. That is the oath all judicial officers took. That whatever you do to me, when you come before me and you have a case, I will operate from a much higher moral ground than you. And that's how we intend to proceed today, tomorrow, until the task before us is done with. And since you raised it, we all saw this. I mean, we'll be pretending to say we have not read this. If indeed the petitioner chooses to take another path, we have no powers as court to stop. We never invited anybody to come to court. If you have a plan B, you don't even need our permission. You pursue your plan B, for us we'll be done with whatever is before us. But as I said, we'll show the difference between judicial function and political function. It will not get into our head. As I said, the Chief Justice, whom I know very well, will not be moved by those things. He will decide, together with his sisters and brothers on this panel, the matters before us in accordance with our judicial oath and conscience. I suppose we can proceed now.
My lords, may I therefore take this same opportunity to thank you for the guidance and for the reassurance that in any case I have been aware of for the last 18 years. Secondly, my lords, receive the assurance of the bar, at least on this side, that anything we feel we need, we will place it before you and nowhere else. Turning to the application before your lordships. My lords, for the record again, my name is Medad Lubega Segona. For the applicant, with the assistance of all counsel mentioned earlier. The application, my lords, is brought under sections 98 and 100 of the Civil Procedure Act.
For how long do you intend to address court?
My lord, I would intend to address you for an hour, but I would be guided by your direction.
Councillor Lubega, you would like to address us for 1 hour on this application?
That's correct, my lord, to the extent that I'm permitted.
That is interesting. I thought you were going to ask me for 10 minutes and finish in 6.
My lord, I must...
Well, I give you half hour, 30 minutes to submit, and don't make me exercise the other power which I have to ask you to sit down. 30 minutes, you'll be done.
I thank you, my lord.
And the responses will also be 30 minutes for each party. You will have 10 minutes then for any rejoinder, if there is one. And you know the rules about rejoinder.
I'm properly guided, my lord.
Yes, so use your 30 minutes.
And
I'm beginning to time you
I will
right
as
now.
well endeavor to use less, because there is an indication from court that you want me to use less, and I will do that, my lord.
No, you have the 30 minutes is yours. Don't be intimidated by court. Just use, don't get stampeded.
Thank you.
Use the 30 minutes.
Thank you, my lord, for the assurance. I feel